Well, good evening, everyone. Thank you for coming along this evening. My name's Mark Moore, and on behalf of Murray Edwards College, I'd like to welcome you to the latest instalment of our On the Edge lecture series, which I'm delighted to say this evening features one of our very own home team. It's my great honour this evening to introduce not just a man, but a still living and breathing legend, the fabulous Professor John Spencer. Professor Spencer is, in short, a Cambridge institution. He is every bit as much a Cambridge institution as Punting, Burnt Cream, Spring Green Hugh, Fitzbillies and the Eagle Pub. Born not too far from here in Chelmsford, Essex in 1946, John has been at Cambridge in some capacity or other for pretty much the past 53 years, and I believe a little bit more. He first arrived here as a student in 1965 and was a fellow at Selwyn College for 43 years, during which time he also served first as a professor of law, where his lectures and supervisions on tort, contract, crime, medical law and criminal procedure and evidence have, like him, become the stuff of legend. In addition, John served as chair of the Cambridge Faculty of Law in the 1990s, where he oversaw the wholesale relocation of the faculty to its current Sidgwick site in 1996, and notably entertained, I believe with great success, the Queen and Duke of Edinburgh when they came to Cambridge to open the new faculty building. John has also served as Deputy Vice-Chancellor of Cambridge University and has been appointed an Honorary Queen's Counsel. Since 2013, we've been delighted to call John one of our own as a By-Fellow in Law here at Murray Edwards College, where his student supervisions remain hugely popular to this day. Last year, Professor Spencer was named in the 2017 Queen's Honours List, where he was awarded a CPE for services to the reform of law concerning child witnesses. John has been a prodigious and highly influential academic voice in this field, where in both his writing and policy work, he has fought relentlessly to reform the procedures and practices whereby young children are required to provide evidence in court under adversarial cross-examination. He has published extensively both in this area and in the field of criminal procedure and evidence more broadly, and has been a member of various influential law reform projects, including for the Home Office and Law Commission. I also think it's fair to say that, like many other people here in Cambridge, Professor Spencer is a committed Europhile who is fluent in 5 languages, I believe, has been an honorary visiting professor at numerous French law schools, and was instrumental in setting up the law faculty's Erasmus exchange programme during his time as chair. Last but not least, for those who don't know, John, as evidenced by the cover of this book of his legal case notes, is a mean puppeteer. His Punch and Judy shows are well known throughout Cambridge, and I believe are available in a choice of either English or Latin. This evening, Professor Spencer will be drawing on his vast repository of expertise and experience, both in the law and more broadly, to address one of the most topical and pressing social and political problems of our time, which is very much close to our hearts here, both as students and scholars. That topic is the truth. Is it dead, endangered, or was it always an illusion? Ladies and gentlemen, I give you Professor John Spencer.
Thank you very much, Mark. Am I audible? Yes. After that most kind introduction, what can I do but disappoint? Well, we all know what this talk is about in general terms. There are some books that have come out recently about the problem of mass misinformation, alias fake news, and there's another of them, if you want to know. And we've seen concern peaking in 2016 with the things that circulated to do with the Brexit referendum. The bus with the doubly misleading claim on it. It was about a 25% exaggeration of how much money is actually sent to the EU every day. And in any case, there's an implied misrepresentation there that it's a large proportion of our national budget. Does anybody know what proportion of our national expenditure is represented by what we pay to the EU? Who thinks it's 10%? 1.1 or 2, is it? Something like that. Anyway, certainly if we'd wanted to sort the National Health Service out, we could have done so quite easily whilst continuing to pay our EU subscription. If that was misleading, you should have seen some of the things that were published more locally in support of it. I don't know how well you can read that. That is a pamphlet that circulated by the Hemel Hempstead branch of UKIP. There's some quite extraordinary claims on it. If we stay in the EU, the Queen will have to resign, we won't have an army anymore, and Turkey is going to join with free movement in 2017. Freely circulated. Lots and lots of people read it. And then, just as we thought we'd made the biggest fools of ourselves in the Western world, there were problems in America, weren't there? And it used to be all right, and it wasn't quite so all right, and now... thank you to my sister for sending me that one, actually. And the American writer, Michiko Kakutoni, I hope I haven't garbled her name, in the book The Death of Truth, which is one of the things I've read in preparation of this lecture, quotes the Washington Post as having added up that in his first year as American president, Donald Trump told a total of 2,140 lies or misleading statements, working out at an average of nearly 5.9 a day. Well, what is happening to truth? How does somebody manage to continue to be president of the United States without apparently doing himself any political damage worth the name by continually lying on that sort of scale? What's happening? And our parliamentarians are worried about it. The House of Commons Digital Culture, Media and Sport Committee, pretty strange amalgam now you think about it. What was it in Peter Simple's column in the Daily Telegraph? There was the imaginary 19th century Sheffield Tramways and Fine Arts Committee, wasn't it? A bit like that. But it produced this very serious report into the whole problem, and then they're very disappointed at the government's flaccid response to it. That was in the Times, together with quite a lot of other news about this general issue just 2 days ago. And if we're worried about that, we have bigger things to worry about, possibly. Private Eye drew my attention to the fact that you can now buy commercially online deep fakes. Deep fakes, these are videos into which you can change and which you can put other people's faces into them, thereby make convincing, wholly false videos of people. And apparently, according to Private Eye, no questions are asked as to what the videos contain or what you might use the output for. There's simply a small disclaimer at the foot of the web page which reads, "Please do not misuse it." Perish the thought. Why does this matter? Well, it's very obvious. If the public is widely misinformed, it makes disastrous political choices and with potentially catastrophic results. Global warming and climate change. Donald Trump denies the existence of both, or if he admits them at all, he says it's nothing to do with mankind and that's all a Chinese myth. And he's pulled, as we know, the United States out of the Paris Climate Change Accord and so on. There are philosophical reasons as well why it's extremely worrying. In Steven Pinker's book, he talks about the Enlightenment and the achievements of the Enlightenment, which are ultimately based on reason and accurate knowledge, and warns us that if the basis of that are undermined, so are all the gains of the Enlightenment in terms of improving the human condition. And at a different philosophical level, my colleague Nick McBride was kind enough to send me a chapter in which he pointed out another problem. Flourishing for human beings requires them to live a life which is a quest for truth, and the quest for truth requires, first and foremost, realism, which means connection with reality. And if reality is distorted and you don't know what's real and false, then obviously there are severe problems there. Well, when the president of the college asked me to give this lecture, I thought of, no, before I go back to that, yes, one other thing. Just two, I thought, why me? I thought of the prophet Jonah. I'm sure you're all aware he spent, 3 days and nights in the belly of the whale. If you know your scriptures, you'll remember that the reason he ended up there was that God had told him to preach repentance to the inhabitants of Nineveh, and he didn't want to. He said, putting it crudely, "Oh God, do I have to?" And he tried to run away, and he went off on a ship to Tarshish, and the ship nearly got wrecked because Jonah was causing it to be wrecked by his ungodly presence there, so they threw him off, and he got rescued by the whale, and everybody knows at least about the whale, if not the rest of it. But I thought, why me? For two reasons. First of all, I'm a technological Luddite. My wife will tell you the smartphone that I bought 6 months ago, I'm now able to use to the extent of sending text messages hilariously mistyped to my wife and other members of the family, but that's about all. And I have never done any form of social media. I've never tweeted, and I've never Facebooked, and I've no wish to do so. So I had something of a learning curve. But on that subject, incidentally, a few things, new words I learnt. Hands up those who know what memes are. Yes, well, a lot of you do, all the younger ones anyway, yes. There we are, that's it. Bots are, I thought that was a technical term to do with potty training toddlers, but apparently no. And of course, it's a shortened form of robots. And clickbait, I know all about that. On the internet, content whose main purpose is to attract attention and encourage visitors to click on a link on a particular web, hence misleading headlines, Queen eats corgi for supper, something like that. But then I thought Jonah got into trouble for running away from the mission that was set to him, so I had better have a go. I can't claim to know a huge amount about all these matters, but I will do my best, I hope not to mislead you with fake information about it. I also thought, why me? Because I'm a lawyer, really. I'm not a philosopher. Lawyers are a group at whom people tend to sneer, either for their venality, or for their mendacity, or for a combination of the two. That's a fair example of the sort of cartoon you find about them, isn't it? But lawyers get an unfair press for that. The reason people think that lawyers bend the truth is because in the adversarial tradition, it's the duty of advocates to put their client's case. Contrary to what people widely believe, it's contrary to the ethics of their profession to put forward a case which they know to be false, but they can put one forward which they suspect may well be false, and it's their duty to have to. But from the court's perspective, the aim of the justice system is to attempt to produce a truthful result. The aim, of course, is often not met, but it's even the publicly proclaimed aim. Now, as you'll see if you look in the overriding objective at the start of the criminal proceedings rules, which says the overriding objective of criminal procedure is to deal with cases justly, and then there's a list of what justly means and is headed with acquitting the innocent and convicting the guilty, i.e. trying to produce a truthful result. And I'm going to start the serious part of this lecture with giving you truth, a judge's eye view, I think, of fact-finding. There are primary facts. Did the defendant's car bump into the back of the claimant's car, or did the claimant's car reverse into the front of the defendant's car? It's sometimes difficult to establish what actually happened, particularly a long time ago, and it's sometimes difficult to establish cause and effect. Sometimes the courts have to decide, was this caused by that? And the courts, of course, have to resort to what I think philosophers call heuristic methods, i.e. rules of thumb, like the burden of proof. He who alleges proves, and the standard of proof in criminal cases, the prosecution have to prove the case beyond reasonable doubt, which means if the court isn't convinced beyond reasonable doubt, they don't make the finding of guilt. But nevertheless, the courts accept the notion that primary facts exist or they don't, and in principle can be found, and that's the end of it. And they treat separately issues of opinion. Not to give you a long law lecture on the difference between primary and secondary facts, opinion can be comment, as in the law of defamation. And you're not allowed to state facts falsely in the law of defamation, but you are allowed to make comments which other people might violently disagree with. And there's a body of law on the difference between a statement of fact and a comment. So when Bernard Levin, that shows how old I am, said of Edward Heath, also RIP now, he is a politician with the vision of a mole, the foresight of a lemming, and the oratorical ability of a whoopee cushion. There's no liability in defamation because that's a comment, not a statement of fact. The courts have to make findings of future fact sometimes, predictions. In this damages claim, because the defendant suffered this or this injury at work, he says that he's likely to suffer a progressive degree of disability as a result of progressing arthritis. And please, he wants a lot of money because of that. And the judge has to decide whether, as a finding to the future, this is made out or not. Predictions. And when judges make predictions to the future, and indeed when they look into questions of primary fact in the area of causation, they often have to rely on experts. But there is judicial caution in respect of expert evidence for reasons that I'd like to show you. The problem of junk science, people being purporting to be expert in fields in which there really isn't any solid body of scientific information on which to go. Classic example I used to use in lecturing on defamation many years ago, the trial of the Lowestoft witches in 1665. They had an expert on demonology. Actually, he was quite a well-known man of science of the day, testifying to how you could tell to witchcraft and the things they did. And as you'll see, he gave expert evidence that the devil in such cases did work upon bodies of men and women by natural inundation. Complete and utter rubbish, as we now know. Junk science, areas of knowledge which aren't actually knowledge at all, aren't based on any solid basis. And then the problem of adversarial distortion of experts, each side calling experts to say the thing that they want their audience to hear. And I have to say, seeing the law's caution in respect of expert evidence and the efforts that have been made in recent years to try and guard against these problems, I have some sympathy with Michael Gove in his much-quoted remark about the country has had too much of experts. I did share with joy the Private Eye spoof about the Gove directory of non-experts. Are you fed up with experts? This directory will give you when your washing machine breaks down. Somebody will come and tell you, I don't know how to mend it. I mean, perfect. But I think he was probably referring to the debate that had taken place in the build-up to the Brexit referendum, when people were being called in by each side to say their particular thing on the basis of not much and If it wasn't junk science, certainly there was a degree of adversarial distortion in it. The title of my lecture is Truth, is it dead, endangered, or was it always an illusion? There's a school of philosophy usually called postmodernism or deconstructionism that on one view of it denies the existence of objective truth and says everything depends on the perception and personal experience of the person talking. And much associated with that, rightly or wrongly, I say rightly or wrongly because I confess I've never read what he's written, and I bet a lot of you haven't either, Jacques Derrida and other French philosophers. And you may, if you're as old as I am or quite a bit younger, you may remember the big controversy there was in the University of Cambridge when the university proposed to give him an honorary degree, and the grant of the degree was opposed by a lot of philosophers who said this is just a load of pretentious nonsense. And I just say in passing, any notion that there is not such a thing as objective truth and that everything depends on the perception of the personal experience of the person speaking is sharply at variance with the legal view. But it's worth bearing this in mind because even though Donald Trump is probably not an expert in the works of Jacques Derrida, some people defending him have actually used that sort of argument in order to justify some of the bizarre things that he said. And in fact, Michiko Kakutani, in her interesting book, quotes a notorious alt-right writer in the United States, Mike Chernovich, writing, "Look, I read postmodernist theory in college. If everything is a narrative, then we need alternative narratives in the dominant narrative." And then he said, "I don't seem like a guy who reads Lacan, do I?" So not only do a lot of people say that that type of philosophy is misleading, but potentially, from a lawyer's point of view, it's dangerous insofar as it causes people to believe that there isn't such a thing as an objective truth. Well, I was talking about is truth an illusion? And it certainly is an illusion to imagine, in case anybody ever did, that there was at some point in history a pure well of truth from which everyone could freely drink, and that it's recently become polluted. Because for centuries in the West, the church and the state controlled what people thought or said. The population, most of which couldn't read, went to church, and that's the doom, or part of the doom as painted over the chancel arch of St Andrew's, Chesterton. You had the basic tenets of the Christian faith painted in murals round the wall, and that's basically everything you knew. Even if you'd had the means of finding anything much else out, most people wouldn't have been able to. The situation changed gradually, and in 1695, there was an end to the licensing of books. Books had to be licensed in order to be published, and that ended. But even after that, it was still dangerous to publish things which offended the authorities in church and state. Thomas Woolston, a don at Sidney Sussex College, not as famous a son of Sidney Sussex College as Oliver Cromwell, but still something reason to talk about him, wrote a book suggesting the miracles of our Saviour might be interpreted allegorically rather than literally, and he got prosecuted for blasphemy for saying that. And more famously, Tom Paine. He escaped prosecution himself, but there were multiple prosecutions of people who sold his book, The Age of Reason, which was a deist book, which was contrary to the teachings of Christianity. Gradually, during the 19th century, prosecutions of this sort stopped, and the laws under which they were done went into desuetude and were much, much later abolished. But all that said, the mass availability of information, and with it the spread of mass misinformation, is very much a modern phenomenon. I'd like you to look at that Punch cartoon from 1906. It's a nice, solicitous vicar's wife visiting an old inhabitant who's unable to move around because he's broken his leg. And she's saying to him that, now that you can't get about and are unable to read, how do you manage to occupy your time? And he answers that. Well, Mum, sometimes I sits and thinks, and sometimes I just sits. And in 1906, there was still a lot of the population that couldn't read, particularly old people. There's a graph, excuse the rather crude colouring, of illiteracy and a gradual falling of the illiteracy level from 1500 to 1900. And you'll see that widespread literacy is something which only came about basically towards the end of the 19th century. So what's wrong now? What's going wrong now, and why? We're concerned about misinformation being spread on a mass scale to a literate population. Going back to the old man there, in 1906, if he'd been able to read, the only thing he could have read that would have told him what was going on were newspapers, and popular newspapers had not yet appeared on the scene, though they did shortly afterwards. And if that were today, assuming there were a vicar's wife available even to go and see him, he wouldn't be just sitting and thinking or just sitting. If he wasn't reading his Daily Mail, he'd probably be listening to the radio or watching the television, or if he'd got a grandchild who told him how to do it, he'd be playing with his laptop, perhaps, or his smartphone, or Facebooking people, or looking things up on Google. An explosion of the possibilities of everybody being informed about everything. An early consequence of mass literacy, but then technological explosions, cheap newspapers, radio and television, and now the internet. And what's been going wrong with it? Which we seem to think it is. Why is it that mass misinformation is spreading to the extent that people are getting worried about it? Well, I think cause number one is irresponsible journalism in the area of the printed word. Let me just give you some examples relating to the EU and discussions of the EU. The European Commission presence in London maintains a Euromyths website in which it patiently exposes the misstatements in our newspapers and other media about the EU and publishes corrections. And here are some I got from it. EU to ban corgis from Daily Mail in 2002. EU to stop barmaids showing cleavages, etc., etc. EU says we must pressure cook our dead pets before burying them. EU plan to liquefy corpses and pour them down the drain. As you may remember, in December 2015, there were catastrophic floods in the northwest of England. And we were at a New Year party safely away from them in Cambridge when we heard somebody holding forth that, of course, as everybody knows, you'd read it in the papers, the cause of it all was EU environmental policy. Completely false. I checked it out. It had been in one of the three of the Sun, the Daily Mail, or the Daily Express, and each of them had rapidly copied it from the other. I worked out about at least 6 million people were likely to have read that, of whom a great many would have believed it. I went to the Euromyths website. Yes, they duly published a correction and said it was all wrong. How many hits? About 2,500. So, leading up to the Brexit referendum, we had had years and years of persistent misinformation about the EU in our sections of our printed press. And I have a personal experience of this because in the 1990s I was part of a project, the Corpus Juris project, to devise a scheme that might more effectively combat fraud on the EU budget. And we devised the idea of a European public prosecutor with power to prosecute for budgetary fraud throughout the European Union. Nobody took any notice initially, and then it was discovered by an extreme Eurosceptic Potty magazine, which wrote it up as a Brussels plot to cause us to abandon our criminal justice system and to make us introduce the inquisitorial system. And then shortly after that, the Daily Telegraph wrote that up on their front page on exactly those lines. A piece of irresponsible journalism as there ever was, because it was plain the journalist who wrote that had never looked at the report. All he'd ever looked at was this crazy traduction of it in the Eurosceptic magazine. And I'm afraid that became the entrenched view in the Conservative Party of what that project was all about. And it resulted in, under the coalition, an Act of Parliament providing we should never have anything to do with the European Public Prosecutor unless we had a referendum. And I used to say that gives me a double distinction as an academic. Many academic lawyers have had their bright ideas ignored by the government, but I think I'm the only one who's ever had my bright idea attract so much disapproval from the government they've actually changed the constitution to make it impossible to be enacted. And there you are, just go on the line and go on the web and see the sort of things that you read about the Corpus Juris project. What's the law on this? Well, the law on publishing false information is that if it's about if it's about people, there's civil liability and defamation or sometimes breach of privacy. But if it's about anything else, it's basically nothing at all. So you can say what you like in a newspaper about the European Union, and however false, nobody can do anything about it, basically. There are occasional exceptions. Misleading medical advertisements are now banned. That's one I found in a newspaper which carried, a Baptist newspaper, which carried the obituary of my great-great-grandmother. And you'll see that that's complete lies, the whole thing. Of course, that's now made illegal, happily. So there are occasional exceptions, but that's basically the position. Next problem. The internet as exploited by social media. Leading to things like extraordinarily false stories circulating around the internet. The Washington pizzeria shootout in December 2016, there's a picture of the man being arrested. There went viral around the internet the story that Hillary Clinton was running a child sex ring from this pizzeria in Washington. And a man drove 6 hours in a car with a gun and shot it up, relying on this. Can you believe it? How does all this happen? Well, it's like this. The business model on which organizations like companies like Facebook work is that they get their revenue from advertising. And the more people who read Facebook, then the more they can charge their advertisers. I don't know why, because personally, if I ever look at Google, I never look at the adverts, but plainly advertisers think people do look at adverts they see on things like Facebook. And they worked out that if they can persuade people to keep clicking, then they can put up their advertising charges. So they use bots, short for robots, to work out what people want to see, and in news feeds, which you get on things like Facebook, they will send you things that they think you might want to see, or that they think you're going to find interesting headlines like Queen eats corgi for supper or whatever. And that is a large part of the problem. It's the abusive use of the internet by social media organizations in order to boost their advertising remedy. The scale of the abuse, well, in one of the many government documents I read about this, it said somewhere that young people check their smartphones around 150 times a day. I didn't know that, but who knows whether it's quite as many as that. I was very surprised. I only check mine if I ever think of it. But and lots and lots of people, particularly younger people, get their knowledge of the news and the current affairs by looking at news feeds from social media sources, all of which tend to be slanted by the companies that are sending them the stuff, trying to send them the stuff that will excite them rather than the stuff that might actually be true. Well, all that was the easy part of this talk. Now's the hard part. If that's the problem, whatever do we do about it? What are possible solutions? Well, the reflex reaction of Parliament is new criminal offences. Could we have any? Would they do any good? Well, a number of countries have enacted Holocaust denial offences, for example. And I have seen seriously canvassed the idea of a criminal offence of publishing false information of any sort with a view to influencing an election or referendum. There's a criminal offence, a fairly narrow scope, of publishing false information about a candidate in an election, for which somebody got prosecuted after the 2010 election. Some people have said, well, might we have a more general offence? And in World War II, as people even have to be a lot older than me to remember, under the Defence of the Realm Act, there was an offence of spreading alarm and despondency. And looking around online, again, thank you to the internet, I see some African totalitarian countries have been talking about maybe introducing such a thing, no doubt to put their critics behind bars. There are obviously grave difficulties in enacting criminal offences in this area, but quite apart from the practical difficulties and the dangers that might be to legitimate free speech, criminal offences are of limited use. You have to identify one of the culprits and catch them. And as Dean Swift said, laws are like cobwebs, which catch harmless moths and flies, while wasps and hornets easily break through. So what other solution? Regulation of broadcasting, of the written press, of social media. What are the possibilities there? Such a complicated matter. I can just give you the headlines. As the French would say, pour évoquer le problème, just about. Well, for broadcasting, we've always had regulation of it, currently run by an independent organisation with the rather horrible title of Ofcom, which sounds like something from 1984. And you have to have a licence to broadcast by radio or television, and you commit a criminal offence if you run a pirate radio or TV station without. Ofcom has a code which expects broadcasters to follow, one of which is a duty of impartiality and due accuracy in news. There you are. News in whatever form must be reported with due accuracy and presented with due impartiality. Significant mistakes in news should normally be acknowledged and corrected on air quickly. And Ofcom is actually able to do something about breaches of the Ofcom code. In extreme cases, it can revoke people's licenses. There's an example of them revoking a license not for fake news, but for publishing hate speech. Some very small-scale broadcasting organisation publishing Islamic hate speech had their license taken away. What about the press? Well, it's, to my mind, not effectively regulated. There was the Press Complaints Commission. I was part of the responsibility for setting that up because I was part of the Calcutt Committee which recommended it. And I thought that makes me also rather interesting as one of the few creatures that has ever fathered a eunuch which had already been castrated before it was born. And in the Leveson inquiry, Lord Justice Leveson criticised the Press Complaints Commission as basically not fit for purpose and made recommendations for its replacement with something more effective. Contrary to what you read in a lot of the newspapers who were very much against the idea. He didn't recommend statutory control, statutory regulation of the newspapers. He recommended a more complicated system under which there would be some statutory body which regulated the regulators, but the regulators would have to conform to certain principles which he set out, which included some degree of independence from the press in running it. It wasn't well received by the press. David Cameron took about 30 seconds to say he wouldn't have anything to do with it. There was then a political tussle between him and the rest of the coalition, with Labour Party on the side of the Lib Dems over it. And eventually something was done, and there was a royal charter granted to a press recognition council, I think it's called. But then, meanwhile, a lot of the newspapers had set up their own organisation called IPSO, which was a sort of Press Complaints Commission Mark II, and didn't comply with the things that Levison had said. And a number of newspapers have signed up to that. And meanwhile, there's a rival organisation called Impress, which is trying to set itself up, which comes a bit nearer it. And a number of papers, including the respectable Guardian, which is the last one that has to worry about fake news because it actually publishes corrections, has said it won't have anything to do with any of them at all. And where are we now with press regulation? Answer, basically in no firm position, and I don't see any improvement in the tabloids insofar as I can ever bring myself to open one. Successive governments are terrified, particularly of the tabloid newspapers. Why? Well, do you remember that? How the Sun campaigned against Labour leading up to the 1992 election, and then published that triumphalist front page saying that they'd secured the Conservatives' election in it. David Cameron thought, and Tony Blair in his time, taken very great care not to offend the tabloids, though David Cameron actually got that wrong over Brexit, of course, didn't he? What about regulation for the social media? A lot has been written and said about this, most recently by that House of Commons Committee on Digital Culture, Media and Sport in its report on disinformation and fake news, interim report back in July. A large, rather rambling document of many pages containing many recommendations, but there, in case you're interested, are some of the ones which the government shows at present no signs of following. The social media ought to be regulated by a body on the lines of Ofcom. There should be a new legal status for tech companies to make them responsible for contents published on their platforms. They should be under a clear legal duty for tech companies to take down harmful and illegal material. There should be a code of ethics for technical companies, and international action is needed. We need to have some transatlantic charter and maybe an international code of practice. Well, yes, the trouble with organizations like Facebook is that they're a bit like the Christian's view of God, universal, they're everywhere. And if you're actually going to bring any regulation to bear, how do you actually get hold of them? How do you make them do what it is that the regulator says they've got to do? It's rather difficult, and I think some kind of international action, at least between the countries that are concerned about it, would probably be needed. And lastly, they have said, as has been echoed by others, the need for digital education. People should be taught more about the risks that are involved in the internet, and they should be taught to see the signs of information being false. The bigger picture. I read Evan Davis's interesting book at my sister's recommendation, and many thanks to her for that. He's more optimistic about these things than most people, actually, including myself. He said a number of things. People are susceptible to fake news if they have genuine worries. People was susceptible to fake news about the EU because the EU had been doing badly in a number of respects. It had the currency crisis, the migration crisis. It hadn't really dealt with, just to name two things. And if people have genuine worries and grievances, that makes them attentive to this sort of thing, and we need to attend to those grievances. Well, yes, so we do, if only. Then he said, we need a change of heart by our politicians to make them more inclined to speak honestly and tell us the truth and not waffle and misrepresent things. Well, that's nothing new, is it? Do you remember that? David Cameron, carefully photographed cycling to the House of Commons on his bicycle to show his interest in green concerns, with, as it was gleefully revealed, his car driving behind him with his car and with his clothes and his shoes and his books and everything else that he needed. And there he was. And again, digital education. Robert Lowe, a rather conservative-minded Victorian politician, famously said, actually in Aghast, when he was aghast at the extension of the franchise, we must educate our masters. And he said, we must make sure everybody is properly educated if they have the vote. That's really important. And I think digital education is certainly something that needs to happen. And government should be encouraged to try to push ahead with that. Well, I, early on in my talk, mentioned the prophet Jonah and the whale, and I reminded you of how he ended up in it. It was because he'd been sent to preach repentance to the citizens of Nineveh. And he went there and he preached, and rather to everybody's surprise, they repented. And God, according to the Bible, repented of the evil which he said he would do unto them, and he did it not. But it displeased Jonah exceedingly, who was looking forward to the inhabitants of Nineveh being wiped out or much tormented. So he went off and he sulked in the shade of a gourd, which then God killed off to serve him right. And God said, dost thou well to be angry? Should I not have pity on Nineveh, that great city, wherein are more than 60,000 persons that cannot discern between their right hand and their left? Theologians have been much discussing the meaning of the book of Jonah, and particularly the bit at the end, which is the punchline. To me, the message is, if you preach doom, you shouldn't do so with a secret wish in your heart that you should be proved correct, so that you can say, I told you so at the end. We do have problems, but it behoves all of us to try to adopt a constructive attitude and think of solutions to them. Thank you for your attention, ladies and gentlemen. That's exhausted my knowledge, and I'm sure your patience. Thank you.
Well, I think we've got plenty to talk about from that incredibly stimulating presentation, and a wide variety of people who we'd love to hear from in the back of the many issues that John has touched on in his talk. We have a microphone carriers who will circulate the room, I believe. If you do wish to ask a question, which I really hope you will do, just to put things in context, if you could tell us just before you ask your question, your name and just briefly your affiliation as well. If you are from Cambridge, what department, whereabouts in the university are you from, so we can censor your views accordingly. So, please, questions, comments, insights, challenges. Rachel.
Hi, I'm Rachel. I'm a third-year law student here at Murray Edwards. Professor Spencer was my criminal supervisor my first year. My question really relates to the fact that UK legislation on the right to freedom of information and freedom of speech and privacy especially has come from the European level and come into the UK through that. How do you think British legislators will address this post-Brexit, and how do you think that will affect the sorts of rights that British citizens have in relation to these issues?
On the preserving free speech side of things, we haven't yet pulled out of the European Convention on Human Rights. So Theresa May did say before the 2015 election, when she was Home Secretary, that she didn't see much point in it, and there are extreme Europhobes who regard pulling out of the European Convention on Human Rights as the Brexit Mark II to be achieved someday. So for the moment, we're into that. As regards data protection, which is a topic I didn't really talk about, because it was to one side of it, the likelihood is that if we're going to continue to cooperate with Europe in any way, particularly over criminal justice matters, we shall have to follow European data protection rules, or else they won't give us any data. So I suspect it won't make a lot of difference. Does that answer your question, or does I talked around it like I've told politicians not to?
On the European Convention of Human Rights point, one of my favourite Boris Johnson quotes was one of the main reasons for us leaving the EU is so we don't have to comply with the European Convention on Human Rights, which again, I probably didn't go conspicuously challenged.
Well, again, I did a lecture on this at one point, and I had a slide which was a day in the tabloids. It was about 10 years ago when I took my car to be serviced at Marshall's. While I was MOT tested, while I was waiting, they gave me a cup of coffee, and there were all the tabloids out there, and I got an anti-Europe headline from each of them, one after the other. There were all these crazy stories about dreadful things that had all happened because of human rights. And my favourite one of all, I've forgotten which one it was from, was if we want to break the tyranny of human rights, we must leave the EU. Quite how human rights managed to get the dirty name that it has is a mystery to me. I remember I went to a dinner party once. I was sitting next to quite a well-educated lady who said to me, are you in favour of human rights? No, I nearly said, no, of course not. I think it's quite right for people to be tortured and locked up endlessly by the government without trial, and nobody should be allowed to say anything. What do you think? But I wanted to be polite, so I gave an anodyne response.
I can speak also without the microphone, is okay. So on this issue about human rights, I'm interested in whether individuals have a right to know the truth about human rights violations that states have perpetrated. And I was wondering, what did you think should happen when there are victims of human rights violation and they ask to know the truth about what happened to them, the identity of the perpetrators, to hold them accountable. And then the states say, well, for reasons of national security, we just cannot tell you the truth. So should there be something else? Can there be anything else than the truth? Or should these individuals just live?
I think there have to be occasions when the state declines to tell people things, regrettably, on grounds of national security. I mean, to draw an analogy with an area I do know about, the law of criminal evidence and the circumstances in which public immunity privilege can be, I've forgotten the correct legal phrase at this time of the evening, but anyway, privilege can be claimed by the authorities not to divulge certain things, for example, the name of an informer. And the cost of refusing to divulge it may be that the judge says, well, if you can't do that, we'll have to stop the case, it can't be fairly tried. But it's recognized in that context that the state can refuse to say things sometimes. I don't think in any legal context it can or should be recognized that the state has a right to mislead people.
Middle of the room.
Yeah, Kirsty Allen, University Library. I want to shout out for the work that we're doing in the Cambridge Information Literacy Network. which is helping people to interrogate the materials that they receive. My question is, do you think universities have some responsibility for the growing mistrust of experts, in that we've not actually communicated our expertise in a way that was accessible?
That may be right. Thinking about your question a little more before I answer it, there's a big tendency in universities for people to disappear deeper and deeper into their own specialization. And I'm afraid it's happened with academic lawyers in recent years, a tendency accentuated by the research assessment exercise, research excellence framework, etc., under which your research has to score stars, and there's known things that give you stars, like publishing it in internationally recognized journals. I apologize to my wife, my son, his partner, and my sister who've heard this rant before. But, and unfortunately, these are the journals people don't read, and you don't get any marks for publishing in things which everybody does read. And many years ago, I thought it was important to start writing about legal matters in the general press. I used to contribute op-ed pieces on legal matters to the Times and other papers. Then I stopped when those papers got so big, if you sent them anything, it all got shunted off to page 75, which was the law page, which only SADS ever read. I think you're right. I think it may be that experts do tend to try to write things for other experts and forget that there is a broader public with which they ought to communicate better. And I certainly think that theoretical lawyers ought to do that, and I think probably likewise with other areas of expertise. So my rambling answer to your short question is yes, I think they do.
Thanks. Jill Phillips, I'm a former graduate of John's from Selwyn from a long time ago. Do you think there's such a thing as a partial truth?
Yes. Under the Fraud Act, like 2006, it's counted as a false statement if you make a statement which is false or misleading. There's a well-known proverb, is it, that half a truth is a whole lie, isn't it, I think? And certainly there's such a thing as a half, well, I mean, there's such a thing as a half-truth, but a half-truth is a misrepresentation, to my mind. And is there a catch question to follow that, Jill, or is that it?
No, I'll declare my interest later.
Right.
The back of the room. Yeah, yourself, yeah, in the middle.
I can hear.
Can you hear me, sir?
Yes, yes.
I'm curious your thoughts on, with reference to the brilliant chart on literacy rates expansion over the past 500 years, your thoughts on the rise of the mandatory formal education system in the West in the first half of the 20th century, followed by a roughly stagnation of the mandatory education with regard to years specifically, and how the rapid rise of information across the world wasn't matched with a rapid mandatory increase in formal education.
I think you put your finger on a problem. If everybody can... It's a sad fact that basically benevolent ideas and changes can produce most unfortunate side effects. Something that I often think of in criminal law is the legal problem of child pornography. Now, child pornography was something which I think somebody would have to be very determined to get hold of and usually wouldn't be able to, and prosecutions for possessing it would have been extremely rare, till in the end the internet makes it freely available and lots of people can get hold of it easily and end up looking at it when they otherwise wouldn't have done, and that's an unfortunate side effect. And I think mass literacy without a greater level of understanding is potentially the same problem. When the Daily Mail was founded, it was Alfred Harmsworth, wasn't it, I think, who founded it? Anyway, he gave a copy of it to an aristocratic friend of his, the first edition, and said, "What do you think of that?" And the friend said afterwards, "I put it in my waste paper basket, And having done so, I took it out and I burnt it in the fire because I didn't want my servants to read it. And I'm afraid mass literacy has produced bad newspapers. The problem is exacerbated by bad newspapers then getting on too big a scale and a kind of Gresham's law in terms of content. I'm not fluent in 5 languages, but I can read several others. And if I go to other countries where I can read the language, which I don't do any more than I can help now, I usually buy a newspaper and have a look. And I've noticed, looking in continental countries, that it seems that our newspapers are much cruder and more abusive than most of the others. I used to go to the Netherlands at one time, and my Dutch friend said, "Have you ever seen De Telegraaf?" And I had seen De Telegraaf, and De Telegraaf looked very tame to me. It was a bit like the Daily Express circa 1952, but they were all horrified by it. And then there was an article that somebody sent me by a Dutch journalist who'd spent some years in England, who was going back to the Netherlands, and he wrote as he left, one of the things that he just wasn't prepared for when he came to this country was the culture shock of the tabloid newspapers. I haven't got his exact quote, it was something like, every day for the British reader, a dose of schadenfreude, xenophobia and hate. What is it about the British psyche that wants it? That's another rant my family must have heard previously. But yes, so there is a problem. We must educate our masters better. Yeah.
Hi, I'm Max. I'm an exchange student from Germany in engineering, so I'm not really knowledgeable about anything here. But what do you think about trying to educate people in striving for really the truth, or motivating them to find the truth, instead of just letting them go with, okay, here's a cool story, click on it, and they're fine with it?
Yes, that's all fine to talk about within the University of Cambridge. One of the students on the double maîtrise scheme that I was involved in, who spent 2 years in Cambridge, sent me a French article, which was the experiences of a French student in Cambridge, and she described Cambridge as le cocon, the cocoon. And I realized only when I was old enough to have a bus pass and I started traveling on buses, what a sheltered environment we've actually lived in and we work in when we simply meet intelligent people all the time and reflective people all the time. And unfortunately, large swathes of the population just aren't like that, and there are limits to how far even good education could make them so. I think they need to be protected against misinformation by banning the worst sorts of it, either by regulation or by criminal offences. And that's going to be necessary, as well as the desirable aim of trying to educate people better.
Hello, Professor. My name is Ritvik. I am a Masters of Law student studying in Fitzwilliam College. I wanted to ask your opinion on this phenomenon that we see, especially in the US, where people, because of their Facebook news feeds, they sort of have their own echo chambers where the same news stories or the same type of news stories keep getting repeated. So these aren't necessarily false stories, but they're just incomplete truths. Mm-hmm. And how exactly do you respond to that? Because it's not an exact case of wrong information, but it does lead to a deep political divide amongst people's understandings.
It's a very worrying development, and the American journalist, a Japanese-American journalist whose name I won't mispronounce yet again, in her excellent book, has a chapter about the problem of increasing divisions of society being driven deeper by exactly what you mention. Just as years ago in cities, people tended to gravitate into particular areas, so you get poor areas and comfortable areas, and you wouldn't meet people from the other area and you'd never discuss with them. So the same thing's happening across a broader spectrum by people increasingly reading things which they get online, which reinforce the things that they believe. And that's partly the consequence of the problem that I was mentioning about Facebook and similar organizations feeding people things they think they want to read. And I think we need to do something to make them change their business model and stop doing that. Disable the bots that enable them to do it, for example. Whether we'll ever be able to do that, I don't know. One of the problems is they're so giant, these organizations, and so powerful and so transnational that it's difficult to persuade our politicians to stand up to them. But I think we should try to persuade them to do so.
I would say, I'm sorry, Ian Gordon, Morton, Oxford, a little while ago. I would suggest that there is an issue, as you're suggesting, of regulation, which leads us to suggest perhaps that we should move from the republic to the tyrant, ideally finding a benevolent dictator.
Can you name one?
The closest was from your university, so I think it was Singapore. So.
I'm for regulation, but I'm not for individuals with tyrannical powers. We see extreme worries at the moment. Was it said, to every problem there's a simple solution and it's always the wrong one? When people are worried about things and there doesn't seem to be action, they say we need a strong leader, and somebody comes along and they end up abusing their power. We need regulation under proper legislation which is balanced and which is itself accountable to the legislator. So I'm all for legislation, but I'm not for benevolent tyrants, because I think tyrants never turn out to be benevolent.
My name's Michael Adams. I'm at the Lauterpacht Centre for International Law. Speaking of the topic of regulation, I'd be interested to get your thoughts on the potential for the aggressive application of cross-media ownership laws. You spoke of monopolies, and I'd be interested to hear your view on the extent to which this is driven by the existence of media monopolies with concentrated interests, and whether breaking up those monopolies might be a way of getting through this problem.
I risk getting out of my depth pontificating on that subject. But I feel that is probably true. I haven't been much in France in the last 10 years, but when I was there, they did have some bad newspapers, but they had a big range of newspapers. I think a bigger range than we do. And I think, maybe somebody here knows more about it and will correct me, much less concentration of ownership. I think concentration of ownership is a big, big problem. Rupert Murdoch buying up this, buying up that, buying up the other. And I think he unwisely said, didn't he, to the Leveson inquiry at one point, well, if you want to know my views, read The Sun, wasn't it? So I think it is, insofar as I'm in a position to talk about it, I think it's a big problem. And our politicians should have been much more prepared than they were in the past to use such limited legal powers as they have to prevent more and more takeovers in the media.
Hi, John. So Odette Murray, a fellow in law here at the college. I just wanted to go back to something you said about the criminal process and the pursuit of truth. That's the judge's role to an extent. In your experience, what do you think is presently the biggest barrier to the achievement of that in terms of either rules of procedure or evidence? So getting a little bit away from the journalism, but is there something presently you think is the biggest bar to the achievement of truth? You know, I have lots of American docudramas about the staircase and so forth in my head about the way the adversarial system plays on sort of over-information, under-information and so forth, but whether you had any view on, in the English system, what is the biggest challenge?
Well, quite a lot, but it would take me another lecture fully to develop them. I would have said a few years ago that certainly in criminal justice, one of the big problems were the rules of evidence, which seem to be in many ways extremely counterintuitive, to the point where I'd even say to my supervision pupils, Your way to solve this problem is to ask what common sense would be the answer and turn it upside down, and you've probably got the problem right. Things like the hearsay rule and the rule excluding people from giving evidence unless they understood the nature of an oath, and not having evidence of bad character when somebody's prosecuted for his 17th rape, that he's done another 16, and so on. We've much rationalized the rules of civil evidence a while ago, and we have quite a lot rationalized the rules of criminal evidence, so that's not a problem. I think in criminal justice, the big problem is resources. The fact that our form of contested trial, particularly in the Crown Court, is extremely slow and extremely expensive, and we end up short-circuiting it as much as we can by encouraging people to plead guilty, so you get cop-outs with people pleading guilty to things which are sometimes much less serious than they really did, or in some cases may be things they didn't do at all. And I'd say it's shortage of resources plus failure to apply it sensibly in devising a more efficient trial procedure, particularly for the less serious cases. We've been shutting down magistrates' courts left, right and centre in order to preserve the full panoply of the Crown Court with its wigs and its ushers and all the rest of it. I think we would have done much better to try to develop the magistrates' court as a simpler method of dealing with these cases.
Time for one more question, I think, before we wrap up. At the back, yes.
Professor, my name's Christopher. I'm from South Africa. I'm a prosecutor there, and I'm at Hughes Hall. I'm doing my master's here. And just leading on from that question, I've been thinking a lot. It might be said this is a typical prosecutor comment, but just like to hear your view on the English system and the American system. I once read an article by a South African judge, including the South African system, has a big focus on not having to provide your defense until the very last moment, if you're an accused person. And whereas continental or civil law systems, very soon you have to say, look, this is what happened. You're almost compelled to do that, and if you don't, it can be held against you. And the judge made the point, it was a retired judge who wrote this, that this would save so much time and effort, because as a prosecutor, you tend then to have to cover every conceivable base, and meanwhile, you know that the person doesn't have any defense, and at the end he doesn't, but it's 5 or 6 years later. I know it's a very unpopular thought, but just from your experience, have you ever thought about that, and could one make it work?
Yes, we have, and we do. We're through and out the other side of that problem, basically, in England and Wales. I don't know about Scotland, but we had a huge problem with disclosure, prosecutors not disclosing to the defence the things they had in the cupboard they didn't intend to use, which was resolved by the courts saying prosecutors must share with the defence everything they have that might be useful. But then that legislation brought with it, to the dismay of the bar, particularly the, well, at any rate, part of it that mainly defended, an obligation in Crown Court trials for the defence to disclose a defence statement in advance of the trial, and then added to that the names of the witnesses they intend to call and their addresses and details. So in the Crown Court, the defence are required now to say in advance how they're going to defend the case and who they're going to call in order to support it. Problem solved for the Crown Court. The sort of thing that you mentioned continued in the Magistrates' Court until the Administrative Court, the Divisional Court with Lord Justice Thomas presiding, said in the Magistrates' Court, if a defendant hides his defence to the trial and then springs something the prosecution should have answered, the magistrate should adjourn to give them a chance. The Chorley Justice's case. My wife, who was a lay magistrate for many years, complained to me endlessly about what you've just mentioned. And then she came home one day and said, have you heard of the Chorley Justice's case? And I hadn't. She was one step ahead of me. And when she met Lord Justice Thomas, Sir John Thomas, she went up to him and she shook his hands and said, John, I just wanted to thank you for the Chorley Justice's case. So we're through and out the other side of it and take that message back to South Africa.
One final, very quick question to finish. I'm going to hijack my position to ask this. Now, before I ask it, you have to promise you're going to give a straight answer, no sitting on the fence. The truth, is it A, dead, B, endangered, or C, was it always an illusion? Can't remember who wrote that.
It's endangered, and we need to take steps to preserve it from becoming extinct.
And perhaps we can start taking some of those steps in our post-lecture discussion over drinks outside. So if you are able to stay behind for half an hour or so, please do, and enjoy the refreshments outside. So thank you everybody for coming. And again, thank you immensely to Professor Spencer for giving us all something to, I think, to take away with us. And I should just say, as you're packing up, in the spirit of these On the Edge lectures and our previous lecture series, Capitalism on the Edge, I think one of the abiding themes that Barbara has tried to instill is don't just see the problem, see the solution as well, or at least look for potential solutions. And I think Professor Spencer's lecture has definitely done that tonight, and I think that's something we can all do in various ways, taking these lessons forward. So again, thank you, John, for a fabulous lecture. Thank you.